Now back to the show. This is The Law Show on CL 650.
Welcome back to the program. I'm Sterling Fox. In studio with me, Rudy Kisher and Alex Stojcevic. They are immigration lawyers with Maynard Kisher Stojcevic in Vancouver. We're talking and will eventually talk about the family class category of immigration and immigrant applications to Canada. But we started off just sort of wading through the headlines, and I appreciate this, gentlemen. The one story that's still out there that I would love a comment on. This is, again, with respect to temporary foreign workers and their ability to stay in Canada. The CFL quarterback Henry Burris was in the news in the last couple of days. He used to work for Calgary. I believe he spent last season in Ottawa. Don't know where he's going to land this year, but he will be in Canada because he's going to be allowed to stay. Rudy, I know you're somewhat familiar with the story. He only works, he's a football player. He only works 6 months of the year, and under immigration rules, that doesn't qualify him strictly by the book for any kind of residency options in Canada, does it?
No, it doesn't. I mean, the problem that arises, and I don't know the Burris case, I don't know his background, his education, or anything like that, or how, different avenues that he could have looked at in terms of being able to apply for immigration. But a problem that you have with somebody who works for 6 months the way he does is he doesn't have what's called a permanent full-time job offer.
Right.
And so, that's usually looked at working 12 months a year. So he's not working 12 months a year. And it's not a permanent job offer because it's on contract. And therefore, when people are immigrating, where they get the majority of their points, or not the majority, but a good chunk of their points, is often from they have an employer who's willing to offer them a job here, or they've worked continually in Canada for a certain amount of period, and they get what's called points towards a Canada Experience class.
Okay.
And so he obviously didn't meet either of those requirements and was unable to apply for permanent residency.
Now, he claims that in the off-season, Alex, he administers the Henry Burris Charitable Foundation. He's its president and CEO, and though he doesn't make scads of money, it is nonetheless an occupation that takes up all of his time when he's not playing football. So he says to the government of Canada, no, I do work year-round in Canada.
That may be completely legitimate. I can't really comment on whether or not that's legitimate or not. I have no idea. It sounds legitimate to me. I mean, lots of players have charitable foundations.
Of course, but the only reason this comes up at all is because he had been given orders to hit the road and then complained or appealed, and through some process of making waves, has secured the support of some MP. And now the Immigration Department is going to have a second look at his file.
Well, an immigration officer for an immigration application, for example, has some discretion if they believe that there would be a benefit, to having the person here that goes beyond what the point system indicates. Now, in my experience, and I think in our entire office experience, no one's ever received that. Actually, I can say openly that I don't think I know of one immigration lawyer that can tell me they've had one file where they've actually had that discretion exercised.
Interesting.
So it was added to the regulations to give officers discretion, but since they've had this new system, I've never seen it exercised.
The only place where it's exercised is at a political level.
Okay.
Because the politicians want that power exclusively for themselves.
Right.
They don't advertise that, but that's what they keep it for.
Right. You have a kind of a CFL sidebar story because we mentioned that Burris plays under contract, as Rudy indicated, and it's a year to year. He's at that point in his career. Younger days would have presented him with a multi-year deal, but I think now it's year to year.
On February 21st of this year, the government imposed, as part of a regulatory change to Regulation 209, which is a compliance regulation intended to make employers who are offering people work that are exempt from labor market impact assessments have to meet some of the same declarations and attestations that they would in a labor market impact situation. That has affected all CFL teams because they have to pay an employer compliance fee and file forms called IMM 5802 forms for each and every import player that they bring in from the U.S.
Okay.
A typical team, if I'm not mistaken, has between 12 and 13, 14 import players a year. This has imposed an additional both financial burden as well as compliance burden on each one of these teams. And if you change import players, let's say well, okay, Alex, what's the big deal? 12 times 230. But take a look at the average season. You put a guy on injured reserve, you bring in another running back, or somebody gets cut from an NFL team and you want to bring him in mid-season, you have to pay this all over again and file the paperwork all over again.
Okay.
So now you're asking HR departments and these teams, often who are on, relatively limited budgets. CFL players don't make millions of dollars here. You're now asking them all to add this whole other level of scrutiny that you didn't have before. That's not just the CFL. It's the Whitecaps have to do the same thing.
I was going to say Canucks probably.
The Canucks.
Yeah.
Each one of these sports teams is going to have to do this for every single person they bring into the country.
And this is an example, again, I think, where the government has overreacted and basically taken a hammer to kill a fly, because, this sort of monitoring was basically brought in to sort of make sure that, the worker at minimum wage at McDonald's isn't getting exploited, because they don't have a lot of power.
Right.
They can't, they don't have it's hard for them to voice their concerns in a safe manner where they won't get won't get fired and they won't have any money to meet their rent. We're talking about professional athletes here.
Yeah.
Do we have to worry about monitoring and making sure they're getting paid enough and that they're not getting exploited?
Do we need to worry about the Sedins? Seriously?
Yeah, right. There's one wouldn't sense a great deal of concern about exploitation in professional sports circles, regardless of what league it is in Canada.
Yeah, but there it is. I mean, this is again an example of overreach and a one-size-fits-all.
Well, and let's not forget it's an election year, right? So,
yes.
So this was a story in the summer, and they wanted to make sure that they were seen to react. And instead of taking a reasonable approach, what we have is an approach that is actually is very inefficient.
Well, and I brought up the Henry Burris story because it is an election year, and because this is the sort of headline-grabbing, soft-hearted government thing that they want to be perceived as doing after changing all the rules for the last, 7 or 8 years. Wanted to talk about the family class applications, Rudy, and you've mentioned the word points a few times already in this conversation. When a person applies to come to Canada as a family member, that I'm assuming then I'm applying from my country to come to Canada because I have family already living in Canada. Is that the usual formula?
So that's the usual formula. I mean, it's important to remember immigration in Canada generally breaks down to 3 streams. We have an economic stream. We have what you want to call a humanitarian compassion that deals a lot with refugees.
Okay, sure.
And then we have the family class.
All right.
And the family class traditionally in the past has been the bulk work of immigration applications come to Canada, a large part of it. And that usually starts with not an applicant from overseas, but really from the sponsor here. So the person, they have to have someone who's willing to say, I want that person here. And that is based not on any point system, not on their education, not on the amount of money they have or their skills, but solely on the relationship that they have with the person in Canada.
So there's not going to be a phone call of, Grandpa, I've just received approval to come to Canada. Can I come and live with you? That's not going to happen.
That's not going to happen.
That's not the way the process
That's not
works.
going to happen.
So where do the points come in, Rudy?
So the points only come in for the economic class.
Yeah, they don't exist.
So they don't exist, yeah. So family class basically looks, when we have clients ask, well, does it make a difference, whether they speak English? My wife speaks English. My wife has an education or something like this. That doesn't matter. The entire basis of the application is based on the relationship they have with the person in Canada, and it's very restrictive. A lot of people, they've heard about their cousins coming, and they think that, well, maybe I can sponsor my nephew or my cousin. That is a long time ago. In the early 90s, you were able to sponsor. Under Mulrooney opened up a class that you were able to sponsor, sisters and brothers and cousins. That has been closed off for years now. And you're very restricted in who you can sponsor if you have family members outside of Canada that you want to come here. It's limited to, your spouse, whether that be sort of common law or married or what we call a conjugal class, which is a very small class, actually, and that needs a little bit more explaining. A dependent child. Or parents and grandparents, and that's it. That is the entire family class. You can't sponsor your uncle. You can't sponsor your aunt. There is one little special category which is called the sole surviving family member. That's a very small category. Is if you have no relatives in Canada and there's nobody abroad you can sponsor, then you can sponsor somebody.
So just to clarify this, Alex, if let's just say that there's a male living in Canada who wants to bring his fiance in from the old country, and his parents. So that's, according to what I understand Rudy to have said, that falls within the acceptance levels. What about her parents? Or does she have to become a Canadian first and then bring in her parents?
That's correct. And plus, she can't immigrate as a fiance. We got rid of that back in 2002. So they have to be married or having lived together for a year, or they have to be conjugal, which is a complicated application.
Sounds a little steamy, if you
It
don't
is.
mind.
Yes. Let's step
We
back
have to
a
keep
little
the
bit.
photos in our office in a special file.
Here's a way to distinguish between all of these types of applications.
Okay.
There is something that all applications have in common under our Immigration Act. The way the system is set up is there are two decisions that have to be made about everybody: a selection decision and an admissibility decision. Admissibility is, do you have a criminal record? Do you have serious health problems? Are you a terrorist? Are you a member of an organization that we have issues with?
Right.
That's admissibility, and everyone has to go through that.
Okay.
Okay? Selection is, do you meet the criteria of the category you applied under? So all of these categories that we've been talking about on previous shows, economic categories, the selection decision is, do you have the right work experience? Do you have the language ability? Do you have
The points,
the
right?
age, the points, if you will?
Okay.
That's what selection is tied to. And if we're talking about the old business categories, like an investor or somebody like that, do you have sufficient funds? Do you have business experience?
And those are all, and they recorded in point form, ultimately.
They can be.
Okay.
In the family category, the selection decision is, are you in a bona fide relationship, or is it one that is motivated by immigration gain in the case of a spousal? And then the other definition is this person your parent, if you're sponsoring a parent? So that's the selection decision, and that's how you differentiate between these streams. The selection becomes the relationship if you look at a spousal.
Right.
And everything comes into that. Age difference, how many times the two people have been married, the source country.
How much time they spent together?
How
Have they
much
spent
time
any
they spent
time together?
together?
Did they meet on the internet? And
Religious differences or
Right.
similarities, all of that comes into play on the selection decision for the spousal.
Well, and because there are cultural issues, Rudy, at play here, too, that some cultures do things differently than we do in Canada with respect to marriage, for example, and prearranged marriages. You could end up marrying a stranger in some cultures.
or your cousin.
Right. And how do we, at our end here in Canada, sort all of those cultural nuances out?
Well, to begin with, I'm just going to jump in with this. The marriage has to be legal by Canadian standards. So you can't have two wives, for example, or two husbands. It has to be legal under Canadian law. That's as a first
And
sort of
that's
step.
a problem that comes up, for different reasons. Bigamy is an issue because either they've lived in a country where they're allowed more than one wife, and they're coming and they're saying, well, I've immigrated, I've got 2 or 3 wives, and I'd like to bring them.
Bringing them all with me.
They're not allowed. They're only allowed the first wife.
Oh,
right?
really?
Yeah.
Okay,
the
so we
first
don't
wife,
allow any of the other group.
They
to
don't
get
allow
in.
anybody else to immigrate under the family class, so that's not allowed. And you also have issues where, for example, happens in our practice quite a bit. Well, not quite a big bit, but frequently enough that people, for example, from countries in the Philippines where they can't get divorced, divorce is not legal, and often you're sitting having a conversation, and it's always interesting because you got the couple there, and you're like, well, have you been married before? Yes, I've been married. Are you divorced? And the question comes up, it's like, well, I'm not really divorced. And the husband's sitting there, well, what do you mean you're not divorced? You told me you were divorced.
Right,
and they're like,
right.
well, did you actually go to court? Well, we never actually got around to it. They can't get divorced in the Philippines, and they have to make an application here. There's countries where you can't get divorced, and those people go ahead and get remarried, and we've got a problem because then they're criminally inadmissible because they've committed bigamy.
Oh, even though on their home turf, there's no crimes involved. It's through the prism of the Canadian value system that we analyze their suitability, right, Alex?
Yes, but that's how we have to do it. There's no way around that. I
Right.
mean, it is the prism of what we consider marriage. I mean, we recognize marriages abroad provided that they are legal. They're not illegal in Canada. So if the way they celebrate it is different than the way we do, and solemnize marriage, if you will,
right.
is different from how we do it, it's not a problem as long as it doesn't violate any Canadian laws. So you can't marry somebody who it's illegal to marry in Canada.
Like a 14-year-old, for example.
Right.
You couldn't. So
a very close relative, for example.
Mm-hmm.
That's not legal in Canada. There's an actual statute from
you can't marry your sister. Exactly.
yeah,
you can marry your
that's a
cousin.
statute from
Surprisingly,
1911 or
yeah.
something like that.
Right.
But, so it has to be legal in Canada, and there's very little leeway there. You have to meet those requirements. Now we can say that they're value oriented or not, but I mean, these people are moving here, and those are the way the laws
I mean,
work
it's
in
interesting
Canada.
because when you think about that, Prevention of Barbaric Practices Act that's been passed, right?
Yes.
I mean, you're talking about, it's legal to have multiple wives in very large countries. I mean, take a place like Indonesia, over 300 million people, and the Prime Minister basically called that a barbaric practice.
Yeah, we've taken it another level with that
Yeah.
act. Up till now we've said, look, you can't bring that family member over because that's not legal in Canada.
Right.
Now we're saying it's a barbaric practice. We've actually said that publicly in a statute, that this is a barbaric practice.
Where there's probably 40 countries in the world where it's probably legal.
Well, at least 40.
Yeah.
Well, in the past, no would have sufficed.
Yes, you think no is enough?
Yeah, no, it's not the way we do things here in Canada. That would have been enough.
Now we're editorializing on the no.
Absolutely.
We're talking citizenship and immigration issues on this episode of The Law Show here on CIL 650. Our guests in studio, lawyers Rudy Kisher and Alex Stoichevich from Maynard Kisher Stoichevich, immigration and citizenship lawyers downtown at 1168 Hamilton Street and online at vancouverlaw.ca. Lots more ahead, including kids, those pesky kids. We'll be back after this.